Hello, everyone. I'm Mark Richards. I'm the provost at the University of Washington, and it's my great pleasure to welcome you to the 45th Annual University Faculty Lecture. Thanks, everybody, for logging in. For nearly a half a century, the University of Washington faculty members have chosen one of their own peers to give this distinguished lecture. It's the highest honor faculty can give to a member of their own ranks. Past speakers have been artists, global health experts, physicists, anthropologists. This year's recipient is Jacqueline McMurtrie, the University of Washington Betts, Patterson, and Mines Professor Emerita of Law. Inspired by the Innocence Project's exonerations off of death row in Chicago, Professor McMurtrie founded the Washington Innocence Project in 1997, the nation's third innocence organization. She oversaw the project's growth from a volunteer-led effort to a clinical law program here at the University of Washington. The Washington Innocence Project has exonerated 15 people who collectively served over 100 years in prison for crimes they did not commit. Think about that for a second. I want to say that again. The Washington Innocence Project has exonerated 15 people who collectively served over 100 years in prison for crimes they did not commit. This project has also successfully advocated for laws to protect the innocent. Professor McMurtrie earned her bachelor's and her law degrees from the University of Michigan. She joined the University of Washington in 1989. Her areas of expertise include criminal law and procedure, DNA evidence, and innocence and wrongful conviction. Today, in large part because of Professor McMurtrie's work, more people are aware that wrongful convictions occur. Professor McMurtrie herself notes, quote, "We incarcerate far too many people, and far too many people of color, and hand down sentences that are far longer than anybody needs to be in prison. Wrongful convictions," she notes, "have deep impact on the wrongly convicted persons and on their families." Drawing upon her decades of research and casework in the innocence movement, Professor McMurtrie will discuss tonight wrongful convictions and criminal justice reform. Please join me in welcoming our university faculty lecturer, Professor Jacqueline McMurtrie.
Thank you, Provost Richards, for that kind introduction. I really appreciate the effort that went into rescheduling this lecture as a remote event after the pandemic upended our world. As I am in Kane Hall, I want to acknowledge I'm on the land of the Coast Salish peoples of this land, the land which touches the shares waters of all tribes and bands within the Squamish, Tulalip, and Muckleshoot nations. I want to thank the University of Washington for this tremendous honor, as well as for providing me with an incredible career over the past 30 years, one which allowed me the opportunity to grow and develop as a teacher, scholar, and practitioner. The Washington Innocence Project was launched at UW Law and could not have thrived without the university's support. Because this is likely my last lecture, I want to express my heartfelt appreciation to my family, friends, and colleagues for their unwavering support, as well as my deep gratitude to the amazing students who have inspired and motivated me over the decades. Finally, I would like to dedicate this evening to the clients and families it has been my privilege and honor to serve throughout my career. Although wrongful conviction is one of the most grievous harms an individual can suffer, it's not the only harm inflicted by the criminal legal system. The United States is the world's leader in incarceration. There are 2.2 million people in the country's prisons and jails, representing an increase of about 500% over the last 40 years. People serve longer sentences in the United States than for similar crimes in other countries. And people of color suffer the greatest impact of these inequities. Blacks represent about 33% of the United States prison population, which is nearly triple their 12% share of the US adult population. In the midst of all these inequities, I'm going to focus tonight on the role of government misconduct in wrongful convictions and urge us to advocate for government transparency and accountability, because prosecutors are the most powerful actors in the United States criminal legal system. They have the exclusive power to decide whether and who to charge and what charges to file. After a person is charged, they have virtually unlimited power to dismiss the case or to reduce the charges or limit the punishment in exchange for a guilty plea, which happens in about 95% of felony cases. After an individual is convicted, the prosecutors continue to retain a tremendous amount of power. They can agree to or fight against motions for post-conviction DNA testing. When new evidence of innocence emerges, prosecutors can agree to or fight against the convicted individual's request to have the charges against them reconsidered. Those battles, when undertaken, are costly. Prosecutors are, as newly elected Los Angeles County Prosecutor George Gasson said earlier this month, the people's lawyer. They and the people they hire are acting on the people's behalf. So we, the people, can request and even demand transparency and accountability for their decisions and actions and mistakes. Innocence organizations were founded and are needed because the system does make mistakes. When I founded the organization in 1997, we were the third innocence organization in the country. And now there are 69 worldwide members of the Innocence Network. The Washington Innocence Project mission is to advocate for innocent people across the state who are in prison for crimes they did not commit. We investigate their cases and represent them in court. We also advocate for policy reforms to decrease the system's errors. We started as a volunteer organization at UW Law. 5 years later, in 2002, I transitioned to teaching in a law school clinical setting, starting with the client representation clinic and then adding a legislative advocacy clinic. The Washington Innocence Project is now a nonprofit organization with an incredible staff, moving forward the mission of client representation and reform. So, how many innocent people are in prison? We don't know the answer to that question, but we do know in the United States, from 1989 to present, there have been over 2,700 documented exonerations. In 1997, when I founded the Washington Innocence Project, there were about 300 exonerations. Now there are over 2,700. One of the most tragic consequences is that these individuals have collectively served nearly 25,000 years in prison for crimes they did not commit. Years that could have been spent raising a family, building a career, and contributing to their communities. The number of wrongful convictions continues to grow, even in the midst of a pandemic. They include over 170 innocent people who were sentenced to death. Eddie Lee Howard, the most recent death row exoneree, spent 26 years on Mississippi's death row. His conviction was based almost entirely on now discredited bite mark evidence, new forensic opinions about bite marks, powerful alibi witnesses, and exculpatory DNA testing results proved his innocence. But it took 26 years. This is not an example of the system working. It's an illustration of its failures. So what leads to these failures? In 1932, Yale law professor Edwin Borchardt published a book, Convicting the Innocent, identifying the factors leading to 65 wrongful convictions. We have a lot more data now, but the factors remain the same. Mistaken eyewitness identification, perjury or false accusation, false confessions, forensic evidence which is false, and official misconduct, often working in concert with each other, lead people to be convicted for crimes they did not commit. I'm going to focus on official misconduct this evening, which contributed to the false convictions of 54% of defendants who were later exonerated. And official misconduct occurs when police, prosecutors, or other government officials engage in conduct such as witness tampering, misconduct during interrogation, fabricating evidence, trial misconduct, including perjury, and concealing exculpatory evidence. When we dig deeper into these numbers, there are more disturbing trends which emerge. In general, the rate of misconduct is higher when the charge against the individual is more severe. It ranges from 38 to 39% for robbery and sexual assault cases, and jumps to 70% for exonerations from death sentences. Concealing exculpatory evidence, in other words, evidence of innocence, is the most common type of misconduct, occurring in 44% of known exonerations. However, the innocence movement has only recently started to recognize and acknowledge that these factors are not independent of the inequitable criminal system in which they are based. For clients of color, wrongful convictions often stem from systemic inequities, including racial bias and racism, sexism, discrimination based on gender identity, and socioeconomic inequities. As an example, Blacks, who comprise less than 13% of the United States population, represent nearly 50% of known exonerations. Black exonerees who were convicted of murder are more likely to have been the victims of official misconduct. They are twice as likely to have been the victims of official misconduct for drug offenses. Innocent Blacks also waited disproportionately longer for their names to be clear than innocent whites. Blacks wrongly convicted of murder spend an average of 3 or more years in prison before being released than white exonerees. There is so much research yet to be conducted on the data that's been collected for the over 2,700 exonerations. But behind each number is a story about a person and the harm they and their family and friends suffered as a result of their wrongful conviction. I could talk with you at length and way into the evening about each and every one of our 15 exonerees and 9 freed clients, as well as about the people we weren't able to help. But I wanted to share 2 stories which illustrate the need to address issues of official misconduct and call for transparency and accountability. Larry Davis and Alan Northrop were longtime friends who worked together in the logging industry in Washington before they were charged in 1993 with rape, burglary, kidnapping. They were convicted, and Larry served his entire 17-year sentence. Alan served 17 of his 23-and-a-half-year sentence before they were exonerated through post-conviction DNA testing. The victim described the 2 men who attacked her when she was alone in a home as a blonde and a dark-haired man. But she'd had little opportunity to see their faces because her attackers covered her eyes with duct tape shortly after entering the house. Nonetheless, the victim was asked to work with a composite sketch artist. She said she couldn't provide a sketch of the blonde man because she didn't see enough of him and didn't know if she would recognize him if she saw him again. But she did provide a composite sketch of the dark-haired assailant. This is what was created. The victim had trouble providing the sketch artist with a nose and a mouth, and they decided to put in a nose that fit with his face. After the sketch was distributed to law enforcement agencies and to the public, police received a few calls saying Alan Northrop looked like the composite sketch. And here's a picture of Alan Northrop. So they decided to put Alan in a photo montage to show to the victim. The victim viewed this montage, which had 6 people in it, and she didn't identify anyone as her attacker. It had 6 people in it, including Alan Northrop. So at this point, the police could have considered they were focusing on the wrong person. But after finding out Alan had a blonde-haired friend named Larry, they decided to ask the victim to view a photo montage with Larry's photo. The victim viewed this photo montage where, after an extended period of time, she identified Larry Davis as the blonde assailant. And as you'll recall, the victim initially told police she didn't get a good look at the blonde assailant and didn't know if she could recognize him again. The description she gave was white, young, in his 20s, tall, big guy, long blonde hair, like a football kind of guy. And I don't know about you, but no one in the photos montage looks like they're 20 to me. Here, even the victim wasn't fully confident in her selection. However, instead of considering whether they had the right person, police told the victim they'd not been able to arrest the dark-haired suspect because she hadn't picked him out of the prior photo montage. They said they would try to get him to come in and ask her to view and participate in a live lineup identification procedure. So at the second lineup procedure, the victim quickly picked Alan's picture out of the lineup despite not having selected him out of the photo montage. You'll note that he is the only person who is present in both of the identification procedures. The eyewitness identification procedures used during this case are so flawed that they are the subject of a book chapter written by my colleague, Dr. Stephen Ross at UW-Tacoma. Based on the victim's eyewitness identification, Larry and Alan were convicted at trial. They reached out in 2000 to the Washington Innocence Project, and we spent the next 10 years working towards their exonerations. Every step was a fight. We asked for DNA testing in 2004. At that time, the Washington law allowed the state to decide whether or not DNA testing should be conducted. The state denied our request. We advocated to change the law so that judges could make that decision. In 2006, when the law changed, we went back to the trial judge. The state opposed the request. However, the judge authorized the testing, ordered the testing, which took another few years to complete. When we filed a motion for a new trial based on the exculpatory DNA results, the state opposed the motion. In 2010, the trial judge granted Larry and Alan's motion for a new trial over the state objection. The state refiled charges. The charges were eventually dismissed, but the state would not acknowledge that any mistake had been made, saying, "The reason we don't feel an apology is appropriate is that we feel the cases were prosecuted professionally." After Larry and Alan were exonerated, they filed lawsuits against the state for violating their civil rights. And it was during these legal proceedings that additional evidence of official misconduct was discovered. Here, the withheld evidence included a box of the lead detective's personal notes with reports and names of other suspects, which were never disclosed to the defense. The state withheld from the defense the fact that the victim was under investigation for embezzlement from an employer. Police never investigated the possibility that the assault may have been set up in retaliation for the thefts, and the defense was not provided with the opportunity to conduct that investigation. The lead detective also had a long disciplinary record including 11 sustained findings for a variety of constitutional and policy violations, including excessive use of force, abuse of authority, and dereliction of duty. Some of these violations occurred after Larry and Alan's trial, but they occurred far before we filed a motion for a new trial based on the exculpatory DNA results. And finally, in 2006, the detective was found unfit for duty, which was the second time that had happened in his career, and he was allowed to retire with his full pension. During Larry and Alan's civil rights trial, the state continued to maintain law enforcement had conducted a sound and solid police investigation where the overwhelming amount of evidence pointed to these two men. However, the state settled the case mid-trial for $10.5 million. Since the county was self-insured, the settlement came from the county budget, which is funded by taxpayer dollars. In Larry and Alan's cases, the official misconduct was largely uncovered after they were exonerated by the attorneys representing them on their civil rights claims. The official misconduct was not part of the Washington Innocence Project's motion for a new trial. I want to contrast that with the case of Lester Griffin, where the misconduct was uncovered as part of our post-conviction investigation. As a result, Lester faced choices none of us should have to make. As background, Lester was convicted of burglary and assault in 2009 and sentenced to nearly 24 years in prison. He served 9 years before his conviction was overturned because of official misconduct. This crime occurred in 2008. The victim was awoken by loud knocking on his door. He got out of bed, opened the door, and was confronted by two men. Although both men were partially masked, the victim immediately recognized one of the men based on that man's voice, build, eyes, nose, and the teardrop tattoo under his eye. The victim identified a man by the name of Alexander, who he knew and had spoken with more than 20 times over the past 2 years, because Alexander and the victim's girlfriend shared a child. Based on the victim's identification, the lead investigator interrogated Alexander. During the first interview, Alexander denied any involvement. During the second interview, Alexander admitted he was involved but downplayed his role. He claimed that Lester, Griffin, and another man were the ones who invaded the victim's apartment and committed the robbery, and that he, Alexander, never went up to the apartment but was the getaway driver. Instead of questioning whether they had the right person, the state offered to charge Alexander with lesser crimes and recommend a sentence of only 48 months in exchange for his testimony. Based on Alexander's prior record and the seriousness of the charges against him, he was facing a sentence of up to 208 months. So from 208 months to 48 months is a really good deal. But consider this. In order to present Alexander as its star witness and provide him with the incentive to be a star witness, the state had to discredit the victim, who testified he knew Alexander and recognized him as one of the men who was his attacker and showed up at his apartment. Shortly before trial, defense counsel learned that the lead investigator was on administrative leave and asked the state to provide more information. But none was provided, and Lester Griffin was convicted. We started working on Lester's case in 2009. Thanks largely to his mother, we obtained the detective's personnel file. What the files revealed was disturbing. In 2000, the prosecutor's office filed a complaint against the detective, alleging he made materially false statements under oath at a court hearing. At the time of Lester's trial, the detective was on administrative leave because he was being investigated for sexual harassment and police misconduct. A female officer with the Department of Corrections alleged, among other things, that the detective had placed a pair of women's underwear on her head during the execution of a search warrant, handcuffed her to a chair, and wheeled her into the men's locker room and made sexual remarks towards her. In an interview with a local paper, the detective admitted putting the underwear on the female officer's head and handcuffing her to a chair. He resigned 7 months after Lester Griffin was convicted. The lead detective was also reprimanded and suspended in 2002 for apprehending a suspect without authorization, and while he was off duty, in his personal car with his children. Based on this and the additional actions he took, the police department found that there was sufficient evidence to substantiate the allegation that he failed to exercise diligence, good judgment, and failed to promote the interests of the department. This was the evidence the state withheld before trial. The Court of Appeals ruled that the state violated Lester's constitutional rights. It granted a new trial. Now, an appellate court cannot, except in the rarest of circumstances, dismiss a case. It can only, as it did in Lester's case, order a new trial. When his case was sent back to the trial court, the state offered Lester a deal. If he accepted the offer, he could immediately return home to his family. When Lester was arrested, his children were with him. His daughter was 1.5, and his son was in kindergarten. When he was offered the deal, they were 9.5 and 14. If he turned down the deal, went back to trial, he risked being convicted and resentenced to 24 years. His children would then be 25 and 30 when he was released. How could he take that risk? Why put faith in a system that had already convicted him for a crime he didn't commit? Why put his faith in a system, as Lester eloquently stated, is designed to keep African Americans like him in bondage? Lester made the difficult choice to take a no contest plea and accept the state's offer. His children did not know he was being released. So here are Lester's children's faces when they saw him out of custody for the first time in 9 years, and the hugs that followed. Lester Griffin is a beloved member of the Washington Innocence Project family. We understand and respect his decision, and it doesn't make him any less innocent in our eyes. What I don't understand or respect is why Lester was forced to make that choice. What is it about the culture of our criminal legal system that allows the state to have a second chance after it obtains a conviction by concealing exculpatory evidence? The answer to that question is one that we need to address when talking about systemic reform. There are remedies, but they require us to imagine a system that is very different from the one we currently have. First, open file policies. Open file policies would require prosecutors to provide the accused with copies of and access to any documents pertaining to the criminal matter that are in the possession, custody, or control of the state. The state would then not have to decide whether evidence was exculpatory. Instead, defense counsel would make that decision. It's a matter of transparency. Transparency would also require that identification procedures, witness interviews, and interrogations be recorded from start to finish to provide an objective and complete documentation of all of those procedures. Instead, what we have are law enforcement and the accused coming into court giving a narrative of very different events that happened during those procedures. Transparency requires recording. Accountability can be achieved through disciplinary procedures. Government officials are rarely disciplined for the misconduct that led to a wrongful conviction. Some discipline, broadly defined, was imposed in 17% of exonerations with known official misconduct, but not in the remaining 83%. Accountability requires differences in local culture to be led by local leaders. Prosecutors have the power to remedy official misconduct by several means. They can implement open file discovery policies. They can discipline or discharge deputies who commit misconduct. They can dismiss charges in cases tainted by state misconduct, such as Lester Griffin's, refuse to file charges when the arresting officer has a serious history of misconduct, or decline to call officers as a state witness. They can prosecute officers who intimidate or abuse suspects or witnesses or frame innocent suspects. They can reinvestigate past cases to see if misconduct was committed or miscarriages of justice occurred and exonerate any innocent defendants they identify. Or they can simply agree not to expend state resources, including those of their office and those of the courts, to oppose DNA testing motions or motions for new trial based on new evidence of innocence. Across the country, there are a number of prosecutors who have promised to change their office's culture. Jason Williams, who was sworn into office as the Orleans Parish District Attorney, described a fight to undo 300 years of backward thinking, including a legacy of one of the highest incarceration rates in the country. More specifically, Jason Williams has vowed to transform a win-at-all-cost culture that he says has pervaded the DA's office for decades and nurtured aggressive and unethical prosecutions, leading to wrongful convictions, excessive sentences, and community distrust. He hired, as the head of his office's Civil Rights Division, the former executive director of the New Orleans Innocence Project. If prosecutors are the people's lawyers, we can request, even demand, a change in office culture to reflect different norms, which means not being quiet. To quote the brilliant Amanda Gorman, the National Youth Poet Laureate, we've learned that quiet isn't always peace, and the norms and notions of what just is isn't always justice. In that spirit, I'll end with a photo of a march in Memphis, Tennessee, which was organized by exonerees as part of the 2018 Innocence Network Conference. We marched from the conference site to the National Civil Rights Museum at the Lorraine Hotel, where Dr. Martin Luther King was assassinated. I love this photo of exonerees holding a sign reminding us of Dr. King's words, "Injustice anywhere is a threat to justice everywhere." One thing that gives me great hope that we can accomplish reform is the passion and commitment of the younger generation, including my students. They took to the streets over the summer to demonstrate against inequity and systemic racism. They give me hope, because there will always be wrongful convictions if there is racial injustice, and we will not achieve criminal justice until there is racial justice. In other words, we have a lot of work to do. I want to thank you so much for spending the time this evening with me. And now I'd like to turn it over to my dear friend, Professor Kim Ambrose, who's going to moderate the rest of the evening, which will be a question and answer. Thank you.
Thank you, Jackie. It is so great to be here with you tonight. As Professor McMurtrie stated, my name is Kim Ambrose, and I'm one of her colleagues at the law school, where I've had the privilege of teaching with her and down the hall from her for many years. And I'm excited to present some questions to you. You've gotten a lot of questions. Thank you all for the questions that you've sent in before, and you can continue to send in questions that I'm sure Jackie will be happy to answer. You answered a lot of them already, but I'll start with, you ended with how excited you are about your students and what they've been doing, and there's a lot of questions that we've gotten from law students asking, what can they do specifically as they develop in their careers, as they're learning in law school? What can they do if they really want to see reform?
They can, and I think reform is not only the avenue of law students or people invested in the law. Reform, especially in the criminal legal system, can take place through advocating and being aware of what your legislators are doing or being aware of what your county prosecutor is doing. But for those law students to answer the question who are interested in engaging in reform, there's so many different ways that they can participate in that process, not just by representing clients who otherwise wouldn't have the ability to have lawyers were it not for those attorneys. They can work for the legislature, they can engage with nonprofits in advocating for reform. But the important thing, I think, for them while they're in law school is to keep in mind that what they're learning, although they might not always feel it in the moment, will be important when they go out and start their career. And they can be inspired by the students who preceded them, who have done things like get the death penalty abolished in Washington state, overturn non-unanimous verdicts in Louisiana. All of those things were done by University of Washington law graduates who also happen to be my students, so I have to brag on them a little bit.
So along those lines, can you talk a little bit about how law students and even other people that are not yet law students or maybe just our community members who would like to get involved with the Washington Innocence Project?
Yeah, so people who want to get involved with the Washington Innocence Project, the best place to start is to go to the Washington Innocence Project webpage, and there are a lot of opportunities there for ideas for how people can participate in the work of the organization, support the work of the organization. You can do the things like follow us on Facebook and Twitter and Instagram and social media, and be educated and aware of the issues that lead to wrongful convictions, and also, if you are so moved, advocate for reforms to prevent them.
Great. We have one question that's come up about COVID in particular during this really challenging time, and a question about what's going on right now inside of our Washington state prisons, and what can be done to remedy some of the situations that people are hearing about with respect to how people are being treated, how at risk they are.
Things are very grim. The pandemic has really changed the focus of our practice. We spent time starting in March trying to protect several of our most vulnerable clients from the impact of COVID. It is raging throughout the prisons, and the infection rate is skyrocketed since last March and spiked again in the fall. There have been 10 incarcerated people who have died as a result of contracting COVID. There have also been 2 correction officers who have died, and one of the prisons, there was more than a 70% infection rate of incarcerated individuals. We currently represent someone that we're trying to have released to home confinement to his sister's home. He is 78. He's in a wheelchair. He is paralyzed on one side because he suffered a stroke in prison. He can't propel himself in his wheelchair, and he can't write and really can't see very well. So the prison sent his case to DOC headquarters for an emergency medical placement referral, but DOC headquarters turned it down, finding that he was a danger to the community. We've been fighting on behalf of this client since March, and will continue to advocate for him. But what it's taken away from is our efforts to try and prove that he's innocent. Instead, we're trying to keep him alive. He contracted COVID while he was in prison and did survive, but is experiencing pretty significant consequences. So it has really impacted our work because we can't do the investigation that we used to do by going out to the counties where the crime occurred, talking to witnesses. The courts have slowed down quite a bit. But most importantly, it's been a horrible place. Prison's not a great place to be to begin with, but to be there now during the midst of a COVID pandemic has been awful for many incarcerated people.
Thank you. I think there are many people that are concerned that maybe that hasn't gotten out more broadly.
Mm-hmm. There have been some good. I mean, there have been some light shined on it, but people on the inside who are writing about the conditions are really in distress.
Yeah. You showed some different charts about race and exonerations. Have there been any? Do you know what the data is around gender?
Great question. I don't have it on the tip of my tongue. There are fewer women in prison, there are fewer women exonerees, but the wonderful thing that they've done is join together as a community. So they have a very strong community within the Innocence Network and are incredible advocates for not only other women, but for exonerees in general. So women who are wrongly convicted tend to be wrongly convicted of crimes involving their children or their spouses or drug offenses. So it's a different type of conviction and one that just bears its own special kind of trauma.
Yeah, well, thank you. Here's an easy one. Prior to your being a professor, what type of law did you practice? Were you a prosecutor or were you a defense attorney?
Boy, I bet based on my talk, people can probably guess, but I started my career as a public defender right out of law school. So I worked as a public defender here in King County at the Defender Association for about 6 years. And then when I moved to the law school, I was teaching a criminal defense clinic. So my students were representing clients on misdemeanor charges in courts in King County.
We have a question here about, you have originally, Washington, or it was Innocence Project Northwest, has focused on DNA challenges. What kind of cases do you expect to see in the future?
When we started in 1997, we decided not to focus exclusively on DNA cases. So the Innocence Project in New York does, but I decided when I started this organization that we would take both DNA and non-DNA cases. So the 15 exonerations that we have been able to achieve, only 5 of those are DNA exonerations and the rest are non-DNA exonerations, so we were able to discover other evidence of innocence. In terms of what cases I see going forward in the future, there's still potential to exonerate people based on DNA evidence because the technology is always changing, it's improving. You can do testing on evidence items that you couldn't have done 2 or 3 years ago even. But when we look at overall exonerations, the 2,700 exonerations, a large part are ones that are based on something other than DNA testing. It's hard, it's a battle, but you have to uncover new evidence of innocence, whether that be that the person was in a different state, which we've had cases where that's happened, or that they have a rock-solid alibi that just wasn't discovered by their defense attorney. Every case is different, every case is unique, and every case takes a lot of work.
Yeah, so you mentioned a lot about the disparities based on race, both within the system broadly, but also among those who are later exonerated. One person has asked, based on looking at your numbers here at Washington in the Innocence Project, now WASH IP, it looks like a lot of your clients that you've exonerated are white. And are there steps that you can take or are taking to maybe actively pursue cases that would involve folks from marginalized groups?
That is a great question, and it's true. Our exonerees don't represent the typical data that we see nationally, and so we are looking at that, and the short answer is I should have done more, we should have done more to really address those issues. Some of the things that we're doing now are doing outreach to communities within the prison, like the Black Prisoners Caucus, doing outreach to communities outside who are family members, taking a look at the application process and seeing if there are things in the application that could be changed, really thinking about and talking about the case selection process to make sure that we're not, because I know we likely are, biased when we look and screen those applications. And finally, to really remember that diversity, equity, inclusion are an important things for us to consider internally. They're not something that are going to take away from the work. They're something that are essential to the work. So there's a lot of work that Washington Innocence Project can do internally, and that the Innocence Network can also do to make sure that we're living by the principles that we espouse.
Great, thanks. There's a couple of questions that came in about what's called the presumption of guilt, which is a little bit different than the presumption of innocence.
Yeah.
And is there anything that we can really do to fight that, is the question. And you experienced it obviously in Lester's case when they wanted to try him again, as well as with Larry and Alan, right?
And this isn't a direct answer to the question, but once we take on a case post-conviction, the person is guilty. So we have to prove that they're not. But you're right, it often is the process that an individual, although they're supposed to be presumed innocent, actually has to prove their innocence at trial. Education, that's education with the jurors about that before they sit over somebody's case is important. Education of the citizenry that, you know, not every time that somebody gets charged with a crime are they guilty of that crime. And I think that is increasingly people are aware of that fact. When I started doing the work in 1997, the typical response was, oh, doesn't everybody in prison say that they're guilty? No, I mean, doesn't everybody in prison say that they're innocent? And the answer to that is no, but what people now know through podcasts and television series and books is that the system makes mistakes. So it's been a real sea change since I started doing this work.
Yeah, that's great. How does, this kind of follows up a little bit on the last two questions, which is, how does the Washington Innocence Project select its clients?
It's not a scientific process, but it's a process by which we gather a lot of information about the case. So we'll go through the case initially and look at the briefs that were filed in the courts of appeal. Then we'll gather the police reports, the trial transcripts. We'll interview witnesses. We'll interview the defense attorneys. We'll try and find new witnesses if they weren't brought to trial. It's a very document-heavy and very intensive process. We look at whether the case has potential for post-conviction DNA testing, and that involves trying to track down where the evidence is, and it could be in any number of different places, whether it be in law enforcement or the courtroom or the prosecutor's office. So it's a lot of work. I think I've mentioned that already, haven't I? And there are many cases that we decide, even after investigating for years, that we can't move the case forward. We have no idea whether the person's innocent or rightly convicted, but there's nothing that we've uncovered that we could bring back into court.
Thanks. We have a couple of questions now about private prisons, because President Biden has recently called for ending the Department of Justice's use of federal private prisons. What impact do you think this will have on the criminal legal system overall?
President Biden talked about eliminating private prisons as a way of addressing systemic racial bias and racism and disparities, and so that is very important. I don't know as much about the private prison process other than we did have clients who went to prisons in Minnesota and in Arizona, and we had very limited access to them, and they described them as really being terrible experiences because they were far from their families. Now, the federal government and what President Biden did governs federal cases, but the state cases, he doesn't have the authority to do anything about that, so it would be up to the state officials to decide what they were going to do with people who were convicted within the state.
Great. Here's a question, and you kind of talked about this a little bit in the context of your cases, but is there an average length of time that it takes between the time you take on the client and the time the case is resolved?
The shortest amount of time that we've spent on a case is about a year, and the longest amount of time that we've spent on the case is 10 years. Haven't added up the average, but I think nationally the average is about 7.5 years of work by an innocence organization on a case before an exoneration is achieved.
Somebody was looking at your slide and noticed that there was a steep downturn after 2016 in exonerations. Do you know what that's about?
I don't know what that's about. I think perhaps there was a peak in that year because of changing technology and new ways of testing DNA evidence. So that perhaps explained why there was an uptick and then there's now a downtick. And certainly what's remarkable to me, as I said, is that in 2020 there are any exonerations based upon just the challenges that are faced with COVID in getting into the courts.
Great. Well, here's an interesting question. Do you have any podcasts that you like that you would recommend?
Podcasts. I think a couple that really give an idea of what it's like to be incarcerated. One of them is Ear Hustle, which is out of San Quentin. And another is a new podcast series by a UW colleague, Professor Steve Herbert, which is called Making Amends, and that he takes place in the Oregon prisons, and it's a really interesting series to listen to. As well as podcasts, there are movies, Just Mercy, of course, which lived up to the challenge of being almost as good as the book. Ava DuVernay's documentary 13, her film about the Central Park Five, the documentary about the Central Park Five. So there are lots of interesting and moving ways to educate yourself about wrongful conviction as well as the systemic racism that leads to people being wrongly convicted.
Great. Well, thank you. That was also on the list, your movie. So,
okay.
Here's an interesting question. Have you used many forensic linguists?
Yes, we did. We used a forensic linguist early on in the project.
You might want to explain what that is, too.
A forensic linguist is someone who examines known samples of writing to determine who the author of the writing is. So in the cases where we used forensic linguists, I have to give a shout out to UW colleague Gail Steigel, Dr. Gail Steigel. She examined known samples of the law enforcement's writings against the confessions that he obtained from the people we eventually exonerated. So the detective said that he just wrote everything down word for word that came from a suspect's mouth. He didn't do any kind of editing. And she looked at those, looked at known samples of his, known samples of theirs, and concluded that the language was actually the detective's language. So it's a fascinating area of study.
Yeah. So I'm going to have two more questions.
Okay.
One is a little bit more substantive. There's a question about your recommended policy changes, specifically the one about the open file policy. If how would victims and witnesses be protected under such a policy? Thinking of things like domestic violence and gang violence.
Well, in terms of protecting victims and witnesses through an open file policy, the accused has the right to have the evidence that's being brought against that person in order to convict them. So the police reports regarding the actual incident are going to contain the information about the victim statements. The open file policy has more to do with evidence of, for example, misconduct, or when a witness changes his or her story and the prosecution doesn't turn that over because they don't think it's exculpatory. And it doesn't mean that everything that is in the file will necessarily make its way into court, but it allows the person who's representing the accused to make that decision instead of the government.
Thank you. And so finally, the last question that I like very much is, it involves philanthropy. If somebody wanted to make a gift to the Washington Innocence Project, what are your greatest needs, and what will have the greatest impact for your continued success?
That is such a lovely question. Thank you for ending with that. And the best way to support the organization is to go online and make a gift. As much as you are able to offer is wonderful. And the needs of the organization are to keep this incredible staff on board in order to move the cases forward and make sure that we can decrease the amount of time that it takes from investigation to exoneration. And so anything you can do to support that work would be very much appreciated. So if I need to answer the question more fully, I'm happy to do that.
No, thanks. That's a great way to end. And thank you, Jackie, for all of your work and for such a great lecture. And thanks to all of you who showed up and also gave us such great questions. We really appreciate this chance to talk about these important issues.
Thank you. Thank you again. It's really an honor. I really, really am moved and honored. Thank you.